the astronaut Chris Hadfield's rendition of David Bowie's Space Oddity. There are now questions about whether he's infringed the copyright of the song. In other words, whether he owes David Bowie some cold, hard cash. Christophe Van Zyl is a senior associate at Adams & Adams in the Trademark and Litigation Department, on the line from Pretoria. Christophe, good afternoon to you. Thanks for your time. Copyright laws, publishing agreements, they often talk about the territory they cover as the world. What happens when you're not in the world?
Well, good afternoon, Stephen. That's a very interesting question. You know, as the law develops, then obviously laws are created with a certain intention in mind, and as the law develops, with technology does not always keep up with that. So when the world's copyright laws were created, of course, for example, South Africa, our Copyright Act goes back to 1978, which was just at the beginning of the space age. It wasn't really contemplated that people would be broadcasting from space or creating musical works from space. But actually, Stephen, in reality, the same rules that apply on Earth will often be applied to a situation in space, but the results may sometimes be slightly different. Let me give you an example. In terms of the South African Copyright Act, copyright subsists in a musical work in the author, and what determines whether or not copyright subsists in terms of this country's laws is not where the work is created, but the citizenship, domicile, or place of residence of the author. So if I went to the moon, hypothetically, and I wrote a song, then as a South African citizen, in terms of the South African Copyright Act, I would still be the author and the owner of the copyright, provided that all the requirements for subsistence are still met. What makes this complicated, though, is that copyright laws are generally territorial. Although there is a convention known as the Berne Convention that sets out the basic criteria for copyright to subsist in music, the laws of each country are slightly different. And in this particular instance, the song was written on the international, the song was performed, on the International Space Station. And in terms of the laws of the United States and the European Union, there's an agreement that the space station is deemed to be within the territory of the United States in certain portions, and other parts of the space station are deemed to be within the territory of the European Union. So those specific circumstances would depend on what the laws of those countries state. But as so far as South Africa is concerned, the mere performance of a song in space, especially if it's private, would not necessarily result in an infringement in terms of our copyright legislation.
Could David Bowie, presumably if he still owns the copyright, could he decide, you know what, it's cool that someone actually performed my song, Space Oddity in Space, I'm not going to ask you for the money? Could he make that decision?
He could. Copyright really is the right to reproduce, and what copyright legislation says around the world is that the owner of copyright has the exclusive right to authorize other people to reproduce a musical work, or to broadcast it, or to perform any other act in relation to the work that is an act that's defined as being exclusive to the author. So if David Bowie decides this is cool, my song is the first song that's being broadcast from space, I'm not going to complain about this, or I'm not going to charge a royalty, then that